So, hello everybody. Welcome to the Swiss Patent Litigation Fireside Chat. It's already the 27th edition, the last Wednesday of a month, this time October. I shared the agenda upfront on LinkedIn. I will pretty much stick to that agenda. One new addition to the agenda, a judgment that has been published on Monday. I will add that one, and just a few housekeeping things up front. Whenever you have a question or a comment, please feel free to leave that one on LinkedIn. I will keep an eye on that and pick it up on the go or afterwards if I don't manage to see that. Otherwise, you're of course also always invited to share your questions before the meeting in the comments so that I can directly address that one for sure. Which brings me right to the first case that I brought with me. I will put the slides on. The first one is about a case about emojis and how these emojis are transferred via a mobile communication network. In a nutshell, the invention is all about saving the necessary data that is necessary in order to transfer an image over a mobile network. If you type a semicolon and a rounded bracket, that is only then transferred in that way, semicolon and a bracket over the mobile network. And at the receiving device, it's translated to a winking smiley. And that, of course, reduces the data amount that has to be transferred over the mobile network. That is pretty much what the invention was all about in this litigation. That was litigation between Pear and three Apple entities, actually. The first Apple entity was the one in Cupertino. The next one, Apple Distribution, that was an Irish entity. And then finally, the Swiss entity, Apple Retail Switzerland. These three Apple entities were the defendants. And I understand that the patents were alleged to be used by Apple's iMessage service. The patents had already lapsed quite a while ago. And when I say quite a while ago means this litigation has been pending since 2020. It's one of the longest pending cases that the FPC has been seeing so far. It was an infringement action, as I said, and Apple, of course, countered with a nullity plea in defense. And in a nutshell, the judgment holds that both patents were invalid. The one only as granted, and it was only defended as granted. And the other one was also invalid in 5 limited versions with inter partes limitations. And the FPC went a long way. It addressed all potential nullity arguments. It explicitly said that it could have stopped at unallowability of the amendments that were made during prosecution, but it also addressed novelty and inventive step, and also for these reasons, either novelty or lack of inventive step, those patents were held invalid. Infringement had thus not to be dealt with, and accordingly the complaint was dismissed. It was a pretty costly exercise. It was 100K court fees, 100K legal representation compensation, and 100K for the assistance of a patent attorney. So all in all, it was 300,000 to pay for Pear. In this case, why has it been so costly? It's not only between the lines that you notice that the court was not happy with the parties. And at one point, the judgment says that both parties did everything to inflate the proceedings, and maybe the court was even a little bit more unhappy with the plaintiff than with the defendant. In my reading, that's definitely not something you want to see in a judgment as an assessment of your argument. Das ist mit Verlaub Unsinn. That roughly translates to this is, with all due respect, nonsense. Whenever I read mit Verlaub, I'm reminded of this young man here. This is the early Joschka Fischer in the Bundestag. Just Google what he said. Mit Verlaub, maybe it's only me who is reminded of that, and maybe it's only because I'm German, but I can't stop thinking of the early Joschka Fischer. Anyway, on a more serious side about that judgment, I stumbled across one addition to the set of presumptions on obviousness. I think it's actually the first time that I read this paragraph in the presumptions on obviousness. And I largely agree with that, but I just would like to put that a little bit into perspective, because I don't think that it's universally true, but well, what is? So the first sentence simply says, well, the closest prior art is what is disclosed in a single source of information as a combination of features. That's a no-brainer. That's also so in the guidelines of the EPO. That's really a no-brainer. The second sentence is essentially saying if there is a prior art document with various embodiments, then the closest prior art is only one specific embodiment, because only this one specific embodiment discloses a specific combination of features. Sounds about right, and I think this sentence is inspired by the famous scissor catalog decision of the EPO, which is T305 of 87. It's a very early one. That decision dealt with a document that essentially, well, consisted only of distinct embodiments, scissors in a catalog. As I said, it's a head note of the decision. But I'm not so sure if that is identically transferable to a situation that is, for instance, at stake with a typical patent document. And moving on to the last sentence and says it's unallowable to already combine at this stage of the assessment of obviousness, to combine this embodiment with further features that are not clearly and unambiguously disclosed in the context of the specific embodiment. And you see the footnote 44 there that says, well, we decided it like that already in the animated lung case quite a while ago, but there it was only about novelty, and now it's transferred to the assessment of obviousness. And I again agree, it can't be a different standard in defining the novelty, the set of features that is relevant for the assessment of novelty. It can't be any different with the relevant set of features that are the closest prior art. But, and that's important, there is case law, and that's also cited in the case law book. I already commented that one on the blog earlier this week. There is case law that says it is absolutely admissible to combine features from the general specification of a patent document with a specific embodiment in the very same document if the embodiment is representative of the general teaching. Then it's perfectly okay to combine the specific embodiment with further features from the general specification. So if that is meant with clearly and unambiguously disclosed in the last sentence, then I perfectly agree with that. But yeah, it still remains to be seen how the patent court really puts this new presumption on obviousness into practice. It didn't have to do so in the case at hand here. So that is pretty much all I could say about this case. The next one is a judgment of the Federal Supreme Court that has been published on Monday, 2 days ago this week. That's litigation between Novartis and Mepha, and the subject matter at stake, the active ingredient in the pharmaceutical here is deferrasirox. A little bit of history on that case. A PI has been issued by the Federal Patent Court back in December 2021. And this PI has been lifted in main proceedings then in April this year, earlier this year. And the main proceedings ended with a finding of non-infringement under the doctrine of equivalence. In the PI proceedings, it was the other way around. It was held to be an infringement under the doctrine of equivalence. The difference there, it was, well, first, of course, it was just summary proceedings earlier on, and now it was main proceedings, but the main proceedings were conducted with an enlarged panel of 5 judges, but the judge rapporteur was the same in both cases. And of course, Novartis appealed, fair enough, and the Supreme Court now held that the judgment of the Federal Patent Court was okay. Novartis' appeal was dismissed, so the judgment of the Federal Patent Court is now final. Now, what did the Supreme Court say? I will just put this one paragraph because I think it summarizes pretty well what has been at stake. So it was only the assessment of the third question that was appealed by Novartis, and this is the only thing that the Supreme Court jumped on. And well, the Supreme Court pretty boldly says, well, the appellant could not explain the sense of a precisely defined set of numerical values in the claim that comprises the preferred value from the specification, if it was not the sense of it that you just disclaim what is out of that range. And if you don't want to be fixed on that range that you claimed, then, well, you had it in your own hands to define that range. You failed to do so. You did not define an open range or a broader range, but you defined a closed range, and there is no clear hints in the specification that this range could be enlarged, and that's, well, in a nutshell, why there is no room for infringement under the doctrine of equivalence. So it's the first time that the Federal Patent Court and the Supreme Court had to assess infringement under the doctrine of equivalence in case of numerical ranges. And it's a pretty clear statement now from the Supreme Court, which in my reading makes it pretty hard to argue for infringement under the doctrine of equivalence in the future for a closed range of values in a claim with preferred embodiments in the specifications that are within this range. Yeah, I can't say that I'm unhappy with that because we were involved in that case, just as a disclaimer notice. In my reading of all the decisions on equivalence in the recent years, my take on that is that the pendulum is swinging back a little, at least after pemetrexed. And again, I'm perfectly fine with that. In my mind, the doctrine of equivalence is simply not meant to fix what I would call sloppy drafting. If you had it in your own hands to define a broader claim, and it was pretty clear that you could have done that. Everybody understands that you could have done that. So the patentee should have understood that as well and did not claim it either way. So yeah, I can live with that. We need to see how decisions on the doctrine of equivalence will play out in the future. That is pretty much what I could say about this judgment. The next one is a judgment that has been published earlier this week, also on Monday. It's a pretty long one. It's about, I think, 90 pages, and it's in French. I did not digest everything right now, but we already have commented on the blog about the main hearing that was held. I think it was in April or May already. So it took quite a while for the court to come up with a decision. And yeah, I have a vague feeling why that was the case, but I will come to that in a minute. Yeah, it's a judgment about a pretty special kind of watches. If you're very familiar with fancy watches, you might know the parties. I did not know either of them. The plaintiff is Global Force and the defendant is Pernell. I will show you the watches that are at stake. First, a watch from the plaintiff. That's quite a beast with 2 tourbillons, and the price tag is, I think, around about 400, 500K of this watch of the plaintiff. And here are the watches that are at stake on defendant side. The attacked embodiment is the series of watches that are abbreviated with Escape 2. Again, 2 tourbillons here, or spherions. We will see that in a minute, whether that matters or not. But these are the attacked embodiments, and likewise, they are pretty expensive. I will show you that one. I tried to find the prices of these watches on the typical websites, and when you look here, for instance, that's a very fancy one where I think the whole housing is made from sapphire. That's about 2.2 million. This one here with 1.4 million has a lot of diamonds on it, but if you're not willing to pay that much money, I think it all starts with 450K. So it's still far beyond my budget for a wristwatch, but yeah, be that as it may. So there's quite a lot of money at stake. Now, what's the patent all about? The patent is, and I put the first claim here, it's, well, a timepiece movement. Well, there is a lot of typical features, a source of mechanical energy, a going train, a time base with 2 balances, and so on. And then there is a differential gearing. And what does that differential gearing do? That's in the characterized part. There are 2 tourbillons, each having a cage and carrying an escapement and a balance. And said cages are being driven, at least indirectly, in rotation by said differential gearing. So that's a pretty straightforward claim, I would say. And in paragraph 6, there is the general aim of the invention. Well, you want to have deux balanciers spiraux that can have a large diameter, and they should have a little risk to couple, and you can address that with the 2 tourbillons. And what is important here to note, the last sentence in that paragraph is, there the patent says, well, the term tourbillon has to be understood broadly, and it in particular covers also carousels. Yeah, that pretty much foreshadows the outcome of that case. In first place, the defendant said, we are not having 2 tourbillons, but we have rather spherions. But the judgment says, well, in broader sense, you have tourbillons in view of the teaching of the patent at stake, which I just mentioned here in paragraph 6, for instance. And that quite well reads on 2 tourbillons. That was pretty much the infringement side. So infringement was held to be given. And then On the nullity side, it was not just a nullity plea in defense, but it was a counter complaint for invalidity, which is the reason why there were 2 file numbers at stake. That was a nullity complaint. And yeah, how shall I say that? I have a vague feeling that a patent attorney might have helped defendant's case. In various instances, the judgment says that there was a lack of explanation how the prior art would have to be modified in order to arrive at the claimed subject matter. And yeah, so there was no patent attorney involved on the defendant's side, and maybe there was maybe more potential in the argument, which I cannot really judge from without reading the files, but I get the impression between the lines that there was more potential in the arguments. There must have been one document on file, which was MICE 1990, that showed 2 escapements in a very detailed embodiment and how they were coupled. And then in passing, that document obviously said, you could also do that with 2 tourbillons, but it was really just a mentioning in passing, and it was not clear from that teaching how that could be reduced to practice. So the judgment holds, well, that teaching was not an enabling teaching of how you would actually do that, and it was only the patent the patent in suit that showed how you could do that. And yeah, I cannot know how that argument could have played out if it would have been argued differently. But at least in the way it was argued, it was not convincing for the court. So the judgment also arrives at a finding of validity of the patent in suit, and that's the outcome. Infringement, yes. The counter complaint for invalidity was not approved. So that meant there was an infringement. And now, yeah, the next stage of the proceedings will then deal with the damages. Of course, the defendant can appeal the judgment to the Supreme Court before, and we need to see whether they do that or not. That remains to be seen. So that's what I wanted to say about this decision. Now moving on to a decision that was not issued by the Federal Patent Court, but rather 1 or 2 weeks ago from the Enlarged Court of Appeal of the EPO, but it has definitely a large impact on proceedings in Switzerland. That was G1 of 22, and that is joined with G2 of 22. A lot has been written already on the blogs and on LinkedIn. I think pretty much everybody knows the head note. By now, I will briefly say what the head notes say in my reading. In a nutshell, it's simply saying head note 1, we, the EPO, we are competent to assess the entitlement to claim priority. That makes perfectly sense because entitlement to priority also has an impact on what is or is not prior art, and what then has to be assessed on the merits by the EPO. So any other outcome on that question would have really been a surprise, at least to me. And then there is a second paragraph on the first head note saying that there is a rebuttable presumption for the EPO that the one claiming priority is actually entitled to claim priority. So rebuttable presumption is a key word here. And the reasons of the decision make clear that this rebuttable presumption is a strong presumption. So it will not be sufficient from now on to just say as an opponent, for instance, oh, the applicant of the priority application is not the same as the applicant from the European patent application, so priority has not been validly claimed. This will definitely not be sufficient, but it has really never been sufficient. But if there are indications on file, and the stronger indications, the better. If you can provide indications that there is a bug in the entitlement to priority, the EPO will look at that, and they have to look at that, even though the rebuttable presumption is strong. Of course, the stronger your indications to the contrary are, the better your case is. And then the second head note deals with the specific situation that had to be addressed by the enlarged board here, which was about the PCT joint applicants approach. And well, it simply says, well, this rebuttable presumption also applies in the case of the PCT joint applicant approach. Yeah, that's pretty much what I can say about the enlarged Board of Appeal decision. One pressing question maybe is, well, how does that now relate to national proceedings? Is that assessment by the EPO, is that binding? What will national courts do? Will they do it the very same way, or will they do it differently? The judgment, no, not the judgment, the decision of the enlarged Board of Appeal pretty clearly says that the problems that the EPO has are different from the issues that national courts have. The EPO has no conflict of law rules. There's nothing in the EPC on that respect. The distribution of the burden of proof is maybe different in the national jurisdictions. And yeah, it's pretty clear. And in reasons 115, I think it is, the enlarged board explicitly says, and I will read that, the EPO's competence to assess priority entitlement does, of course, not imply that national courts are bound by the EPO's assessment. So this in no way prejudices the practice of national courts in the assessment of entitlement to priority, at least in my reading. But we shall see what national courts will do with that. Yeah, which brings me to yet another issue that relates to the EPO, which is quality at the EPO. Quality at the EPO, quality is, it means different things to different people. To say that upfront, the EPO is really by far my most favorite patent office, but still that's a reason why I'm concerned when people complain about quality, and no quality will ever be perfect, not even at the EPO. Not sure if you have seen the post that I made in July. Here it is. That's a post that I made about quality at the EPO. I felt a need to expand on quality issues at the EPO because I have seen documents, emails sent by a director of the EPO to his examiners, and it's a director who is responsible for 3 directorates. That translates to about 200 examiners. So it's really not nothing, and I was not so happy with what that director wrote to his people in terms of quality, and that then gave rise to some discussions on LinkedIn, and I will show you maybe first the next slide. Oh no, I will go to LinkedIn first. That gave rise to some discussions on LinkedIn, and a colleague, David Houghton from HGF in the UK, he looked into the EPO's PetStat database that contains inter alia all the numbers of grants and refusals and 71(3) notifications and so on. And he digged into those numbers, and after some discussions with him, I asked him, could you please do me a favor and provide me with a ratio of numbers of grants per refusal over time? And he did that, and you see the numbers here from 2013 to 2023, which is 10 years, which is quite a long time. And you see for 9 years, it's pretty much the same between 14 something and 18 something grants per refusal. So meaning 18 times more grants than refusals. And it was pretty constant. And in 2023, that value jumped up to 51 grants per single refusal. How can this be explained? There is a single explanation that I heard, and of course that's right. That can explain it in part if you only look onto the number for 2023, which is the UPC. The EPO allowed users to request a deferred grant in order to benefit from the UPC, the Unified Patent Agreement, to have the patent validated as a unitary patent. So that means that there is a reason that could explain a jump in 2023 of the grants, but those grants would have been missing elsewhere in 2022, for instance, if they were just transferred from 2022 to 2023. But there is no lack of grants in 2022 because 15.8 is pretty much in line with all the other years since 2013 of grants over refusals. So I don't think that this jump can be in total explained by deferred grants that carried over from 2022 to 23, because they would be missing in 22 and they are not missing in 22. That was pretty much underlining my concerns that there is a certain pressure to allow cases to proceed to grant, which was also the gist that I took from these emails that a director sent to his examiners from 3 directorates. We shall see how this number in the end is for 2023 when the end of the year is nearer. This number was only based on the numbers that were available at mid of September. But yeah, it might come down a little bit, but it won't come down to 14 or 15. That simply can't be. So it will be significantly higher than the years before. I will look at that again end of the year or early next year, and then maybe draw my conclusions from that and ask some questions then again. There is one further thing that I wanted to show you with respect to quality at the EPO, which is this one here. If you have not seen that already, that's Kluwer Patent Block. I think the second but last entry was a post by Thorsten Bausch, who was referring to a letter that was sent by the Central Staff Committee. It's not directly included here, but it's a first link here in the first line of that post. And if you then go to that letter, this is this one here. That was a letter sent by the Central Staff Committee at the occasion of the 50 years anniversary of the EPC. And the title says, please reward quality in the core business. It starts with a citation from this director that I've also quoted in my post of July. That is also not much new. I'm quoted here, the first footnote. Not proud of that, but yeah, it just shows that the Central Staff Committee is also concerned about that. But what made me concerned here again is this first paragraph on the second page, saying that they urge the EPO to stop changing the composition of divisions until the outcome of the division's work pleases management, whatever that means. I would really like to understand that. The second sentence is maybe even more disturbing. It says, in the case of oppositions, we have even seen team managers and directors acting as hidden members of the division, although there is no provision for it in the EPC. If that means that management really interferes on the substance of oppositions, that would something I would not want to see. Yeah, but the problem here is that this paragraph refers to certain letters. In the footnote, you can see that down here, which are letters by the Central Staff Committee to the Vice President of DG1. But when you follow those links, they are behind a barrier. It's only accessible for staff of the EPO, not for me. But maybe I can find out more about that. And the last sentence there is saying that it cannot be that recent managerial decisions to consider patentable subject matter which is excluded from the patentability according to case law. I have no idea what that is, but if it's just promoted, if some certain subject matter which is not patentable according to case law is now defined as patentable by management, that would be alarming. Again, I will try to get hold of these letters. Maybe I can tell you more about that at a later point. I can't do now. I can only tell you that this is, well, disturbing me, but I cannot really say more about that for the time being. That is already what I had on my agenda for today. I will just look at the comments. If there is nothing in the comments on LinkedIn and I can't see any, then that was it, what I brought with me for today. If you have any questions after this session that you wish to be answered, just drop me a line by email or in the comment section on LinkedIn, and I will always be happy to enter into a discussion or to just answer your question on LinkedIn. Always happy to talk about these things. Thanks for joining this month again. I hope to see you next month, last Wednesday of then November. And has been my pleasure again to see you today, and I hope to see you again next month. Enjoy your lunch, even though it might be delayed today, and enjoy the rest of the day. Bye-bye. Thanks.